Hi folks, I'm Greg McLawsen, the Affidavit of Support lawyer. I help green card holders enforce the Affidavit of Support in lawsuits in federal court. A question that comes up, twice a week at least for me, I've done a video on it before, but we'll do another one today, is how a nuptial agreement impacts your ability to enforce the Affidavit of Support. The Affidavit of Support is required in all family-based cases, immigration cases, but the vast majority of situations where folks end up enforcing the Affidavit of Support are in marriage-based situations. So typically, not always, usually these are lawsuits of one spouse against a former spouse, or sometimes they're still in the process of getting divorced. Well, what then if you have a situation where the foreign national, the green card holder, has signed a nuptial agreement saying that they will not get support from the U.S. citizen? The bottom line is that federal courts consistently say that nuptial agreements do not destroy your right to pursue the Affidavit of Support. Put differently, even if you signed an affidavit of backup, even if you signed a nuptial agreement as a green card holder, and that nuptial agreement says, I will not get alimony, I will not get support from my U.S. citizen spouse, that agreement does not destroy your ability to pursue the Affidavit of Support. You can still use the Affidavit of Support to get the financial support that is promised in that agreement. Let's talk about why. Maybe this is more lawyer talk than you need, but let's go back to 1996 when the United States Congress created the Affidavit of Support. What Congress did, in the United States, we have various welfare programs that provide a safety net for people in our country. These include things like cash benefits, food stamps, Medicaid. What Congress did in 1996 was it took away those benefits from legal immigrants. So it said, even if you come here on a visa, even if you get your green card, you're a lawful resident, you still may not get these public benefit programs for at least the first 5 years of your residence. But rather than leaving recent immigrants with no form of public safety net, when Congress did that, it created a new binding financial obligation for people who bring family members to the United States. That's the Affidavit of Support. So Congress basically said, if you're a new immigrant to the United States, you do not qualify for most public assistance programs. But the person who brought you here has a contractually enforceable obligation to provide financial support to you if you need it. That's the Affidavit of Support. So when these cases start getting into the federal court system and green card holders are enforcing that binding right to financial support, federal courts are presented with the issue of, well, what do you do in a situation where a husband and wife are married and either before the marriage or right after the marriage, a nuptial agreement is signed, a marriage agreement, where the green card holder has said, if we get divorced, I will not get alimony from you or support. Different terms are used in different states all across the United States. Here in Washington State, we call it spousal maintenance. But regardless of what you call it, it's really common for folks to sign nuptial agreements that say, if we get divorced, I'm not going to seek alimony. Well, so you get these cases coming up to the federal courts, and the U.S. citizen says, hey, the green card holder cannot sue me in federal court under the Affidavit of Support because they signed this nuptial agreement. And the nuptial agreement says they cannot come after me for spousal support. And federal court said, okay, what we have here with the affidavit of support is something created by Congress. What was Congress trying to do? Well, very clearly, the intent behind the affidavit of support was to create a financial safety net for recent immigrants. Because remember, what Congress did is it said, if you are a recent immigrant, a legal immigrant, you did everything right, you still do not qualify for federal public assistance programs. And instead, what we are going to do is make the person who brought you here financially responsible for you. And the federal courts say, well, what would it mean if we allowed any sponsor out there to sign the affidavit of support and then the next day, or even 5 minutes later, have the green card holder, who at the time is applying for the green card, have that person sign a nuptial agreement that says, haha, no, not really. Me, the sponsor, the person who's promising this to the federal government, because the affidavit of support is a contract with the federal government. The sponsor would basically first tell the government, I'm going to support this immigrant, and then minutes later, sign a nuptial agreement with the green card holder that says, nope, actually, this person is not ever entitled to get support from me. I am nullifying, I am destroying that obligation that I undertook with the affidavit of support. And federal court said, you can't do that. The purpose behind the affidavit of support is to make sure that the green card holder has a meaningful right to receive financial support from the sponsor. And again, the sponsor made that agreement, made that promise to the United States government. And the fact that he, and it usually is a he, signed a nuptial agreement with the immigrant doesn't destroy that statutory system that was created by Congress. So you cannot, as a sponsor, sign this binding affidavit of support and then, in effect, rip it up 5 minutes later just because of a private agreement that you reached with the green card holder. Federal courts say that you can try to do that, but it is ineffectual. We, the federal court system in the United States, will not give effect to that nuptial agreement. Now, these cases that I was just talking about, this went up to what's called the Ninth Circuit Court of Appeals and the Erler decision about a decade ago. But this is something that still gets fought out in these cases. As early as a few months ago, I was fighting this battle in a case out on the East Coast where a defense attorney showed up and said, hey, a nuptial agreement was signed, and so you can't sue us in federal court. And I said, well, we can. Take a look at the Erler decision. Federal courts say specifically that you can be sued under the affidavit of support even if there's a nuptial agreement out there. And so we had to fight that same battle in federal court out on the East Coast. We, the green card holder and plaintiff, prevailed in that. The judge agreed and became yet one more in this line of federal cases that say nuptial agreements cannot destroy the affidavit of support. But I mention that to say that this is still a battle that has to be fought sometimes, because you will still get defendants and you will get defense attorneys trying to bring up the nuptial agreement as a defense in these cases. But it is accurate to say that federal courts have consistently rejected those arguments by defendant sponsors. Again, this keeps coming up. Prospective clients still have this question of me, and defense attorneys still want to argue about it. So I think we're going to be having this conversation for some years to come. But I hope that's helpful. Nuptial agreements do not destroy the affidavit of support under federal courts to have considered the decision. If you have questions, jump into the comments. If you'd like an individualized case assessment, reach out to me at soundimmigration.com. I talk to folks all across the United States. Hope that's helpful.